Welcome, and thank you for joining Part 1 of Seyfarth's micro-webinar series, Workforce Realignment and Reductions in Force. This installment of the series will focus on reductions in force. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Barry Miller. Barry, you may begin.
Thanks, Brooke, and thanks to all of you who are joining us for the first installment in a four-part micro webinar series on reductions in force. This first segment that Alex and I are presenting today is an overview. It's going to be very high level and directed at issue spotting more than some of the fine details of the reduction in force process. And we'll drill into some of those finer points in the coming episodes of this installment. But for now, we're really just focused on an introductory presentation, and we're going to talk through just the very elemental aspects of a reduction in force and the things that should be in your mind if you see a potential workforce realignment on the horizon for your organization. So I will turn it over to Alex to begin to orient us to those points.
Thanks, Barry. Just as you were saying, something is coming up on the horizon. It might be a reduction in force. If so, as you're moving in the direction, you're going to want to think about a number of things about how the business is going to approach this reduction in force. We have kind of a mini roadmap here of a few points that we're going to want to consider kind of going into things. The first point is you're going to want to be able to identify and document the necessity of a reduction in force. The business is likely approaching the RIF for a number of reasons, and you're going to want to be able to make sure that you can articulate what those reasons are. You're going to want to review some of the existing obligations that the business has that might impact decisions that are going to be made during the RIF process, and you're going to want to create a blueprint where you're identifying the employees who may be impacted. You're going to develop some selection criteria, and you may want to consider creation of a review committee and then pressure test some of these inputs that you're kind of taking into account. For the first step, as you're kind of identifying and documenting the business necessity, there are some legal considerations that you want to take into account. A well-explained RIF is going to be facially legitimate, non-discriminatory, and a non-retaliatory reason for termination. What are the business's goals heading into the RIF? Maybe a dollar amount that's being saved. Is unprofitable work being eliminated? Were alternatives considered? Some of the examples of necessity might be the business is discontinuing a certain line of offerings. It's consolidating some of its offices. It's responding to a change in marketing conditions. Automation has made some jobs obsolete. It's reducing costs, and maybe it's improving efficiency by reducing or restructuring specific job functions. And when the business is looking to then review some of those existing obligations that might impact its RIF, it's going to want to consider some of the policies or agreements that it already has in place. These may limit its ability to conduct the RIF, or it might just shape how it's going to have to proceed. The first consideration might be, is there a union involved? A union means there's a collective bargaining agreement, which might impose certain restrictions or requirements on the business. The business very likely has key policies and documents, employment agreements, offer letters, maybe it's handbooks, historical procedures, including whether or not it has done a prior reduction in force, and whether or not it has a severance policy. These are just a few of the things that the business is going to want to take a look at in kind of seeing the contours and the shapes of how its RIF is going to look. And then it's going to want to draft a blueprint for how it's going to proceed. It's going to identify the scope of the potentially impacted group This is going to take a look at whether or not there's a joint employment issue, whether or not independent contractor issues may arise as it's moving down the road of an RIF. Does it rely on agencies or outsourcing some of its workforce? Does it have any service providers that are on demand? Then it's going to want to look at some of the selection criteria. Key here is that it's focusing on objective criteria. It's looking at the functions that certain roles are providing to the business, not the types of people that are providing them. It's going to try to avoid using salary level as a direct reason. As employees stay with a business longer, their salary tends to go up, which may mean that it may incidentally target an older workforce if it relies purely on salary. And it's going to want to align the criteria then to those stated justifications. So why does the business need to do an RIF, or why is an RIF what's best for the business? And then it's going to want to take the criteria that it decides upon and make sure that they're both in alignment. It should all make sense. And the business should also consider a review committee of the RIF process. The review committee is going to develop the process. It's going to keep notes of the decisions that it's made along the way. And it's not going to keep notes of the deliberations, however, that went into those decisions. The purpose is going to be able to make final decisions on individual terminations. And that's why it's really important to make sure that you consider the composition of this committee. It should be a diverse committee that offers a lot of different perspectives on the business and the workforce. The review committee is also going to want to make sure that throughout its entire lifespan, it is taking confidentiality into account. It's going to only want to be receiving and processing the data that's going to be relevant to it. It's going to want to have a tight grip on what kind of input is going into the review committee. And as you're looking at the reduction in force, there are two kind of different approaches, a voluntary versus an involuntary approach. The voluntary approach is where employees are going to be able to self-select. They're going to choose to leave the company. Now, they're going to be offered this option, but that presents another risk. The offering cannot be done in a discriminatory way, or else you have kind of lost the benefit of reducing the litigation risk. An involuntary reduction in force is where the company, based off of that blueprint we just kind of reviewed, is going to select the employee based off of the function or the role of that employee. Business needs might force the hand, and you may be going down an involuntary reduction in force whether or not you'd rather do an involuntary one. Now, you can combine both. The process should be tailored to whatever your business needs. There's no reason that it has to be one way or the other, unless, of course, there are factors affecting the business that do require it to be completely involuntary or maybe voluntary. And with that, I think we can go ahead and hand it back over to you, Barry, to go over severance pay.
Yeah, this is one of a few things that I'm going to talk about that are a little bit more in the nitty-gritty, and we can back up one slide, Brooke, because we're getting a little ahead of ourselves. Alex has given us a very high level, essentially describing what a RIF is. So we're going to shift gears a little bit into the how-to and things that you may want to be thinking about to mitigate risk that otherwise might arise from a mass termination event. Ultimately, that's what a reduction in force typically is firing a bunch of people. So we're going to talk through a few different steps that an organization can take to limit the risk that inherently goes along with those sorts of terminations. And the first thing that we're going to talk about is severance pay policies, which is a very broad and general topic. It could include anything from a formal ERISA severance pay plan, which I'll talk about in a minute, to an internal handbook policy that commits the company to handling reductions in force in a certain way, to a collective bargaining agreement, as Alex mentioned. And in general, when we're talking about severance pay policies, what we're doing is making decisions in advance. Where a reduction in force is a one-time event, an organization can take all of the factors that Alex has described into consideration in a very specific, targeted, and focused way, where essentially you're dealing with one transaction to right-size a company. A severance pay policy is essentially pre-planning for a bunch of those things, which has two impacts, broadly speaking. One is it's going to make things more predictable because it decreases the number of decisions that have to be made once RIF selection decisions are at your doorstep. The counterpoint to that is it decreases your freedom of movement. You have less flexibility to depart from what might have been prior practice or other expectations if you've communicated all this to the relevant population in writing. With that, we can go to the next slide, which is specific to ERISA-governed severance pay plans. And ERISA is the Employment Retirement Income Security Act. For those of you who are not familiar with it, it is in many respects a tax law. It is a very sophisticated group of statutes, and it applies to severance pay plans in certain aspects, but it's a much broader statute that regulates employee benefits in general. And there are a few things about it that are salient. One is that it has a preemptive effect. It's a federal law where the federal legislature has said, we're going to step in and essentially push state law out of this particular zone. And what that gives you, if you elect to adopt an ERISA severance pay plan, is a much more limited judicial review of certain decisions that are made in conjunction with the layoff process. Most decisions that are going to be scrutinized in the context of an ERISA severance pay plan are scrutinized only for arbitrary and capricious behavior on the part of the plan administrator. In other words, the company has to have done something that's a little bit crazy and reckless for a judge to intervene in a decision that's been made under a properly administrated ERISA pay plan, which from a distance seems like a pretty attractive benefit. But there are limitations on that. One limitation is an ERISA severance pay plan is very unlikely to shield an organization from claims based on the identity of the people selected. In other words, if a certain person is included in a layoff and they assert that they were selected for layoff rather than some comparator because of their race, religion, national origin, or age, having an ERISA severance pay plan is not going to make that claim go away. What it does tend to save you some amount of headache in regards to are disputes about how much severance pay someone should receive or whether they're entitled to severance pay under a given plan at all. So if those things are valuable to an organization, then an ERISA severance pay plan may make sense. My personal experience is that these sorts of plans, because of the institutional rigor that they involve, which in addition to the administration of the plan itself involve certain governmental reporting and providing records to plan participants upon request, when you weigh all those things out, an ERISA-governed severance pay plan tends to make the most sense for a large organization that foresees itself going through reductions in force on a regular basis, so that you can kind of routinize the process, decrease the number of decisions that need to be made for each given transaction, and proceed in a sort of automated capacity. Outside of that capacity, most of our clients find that an ERISA severance pay plan is too much administrative burden and too much restriction on their immediate freedom of movement to be worthwhile. With that, we can go to the next slide. One thing that I'll add, this slide captures the ERISA severance pay plan that I just spent a few minutes talking about. And the reason that we've decided to include that topic in this presentation is that clients ask us about those all the time. When we're dealing with clients who haven't done a RIF recently, in-house counsel and the HR team very often surfaces this question: should we have an ERISA severance pay plan? And we've talked about the substance of that. One alternative that I would put out there for folks to consider is the simple use of arbitration agreements in the employment context. If your employees are subject to arbitration agreements, it's very likely that a lot of the benefits that you might otherwise get from an ERISA severance pay plan, you're going to get from your arbitration agreements with a lesser degree of headache and administrative expense. So other means to mitigate risks. There's a slide on the screen now that will talk through 3 different points, but I think we can go ahead and dive into those. The first is a disparate impact analysis. Brooke, we can go to the next slide on that. A disparate impact analysis is a statistical review of a proposed layoff. In other words, we've made our selection criteria. That's been done presumably by the managers of the organization, vetted by human resources to the extent that that's part of the process. So we have a list together, at least a proposed list of who's affected and who's not affected within a given decisional unit. And several of the topics that I'm going to touch on in the next few minutes really do emphasize the importance of this notion of a decisional unit. What that basically means is the group of people that you're looking at as possible candidates for a RIF. So a decisional unit, for example, might be a particular area of a plant, and it might exclude other areas of the plant that are doing core important work and are not going to get impacted by the reduction in force. It might exclude the C-suite, it might exclude G&A type functions. But the basic idea is you have to figure out who is being compared for purposes of the RIF, who's being selected to be laid off, and who's being retained. Once you have that data, you can do some analysis to determine whether your proposed reduction in force has a disparate impact on anybody in any particular group. And we tend to look at that in age bands, as you see on the screen here. We look at it as a gender question, and then we look at it as a race question as well. And what you're looking at here is the output of that analysis, which includes a few important points. First of all, in column M here, you'll be told whether or not there is a disparity that is statistically significant. In other words, are folks in a given age group impacted at a higher rate than comparators who are younger than them by a statistically significant margin? And for larger groups, we express that as standard deviations. Anything more than 1.96 standard deviations is generally considered to be statistically significant. We also, in our own process, have a Fisher's exact test for smaller groups, because very often when you're conducting layoffs that involve small decisional units, you won't produce a statistically meaningful result that's expressed in terms of standard deviations. And so we have these alternative statistical tests that will tell us if you're impacting folks in an adverse way, even in a small group. And the utility of that is you can project that out to the numbers that we see in columns N, O, and P here. And if you do this analysis and you see that you have a RIF that would pose an adverse impact on a group, you can reconsider those decisions. That has to be done very carefully unto itself. And there's a reason that this document is marked attorney-client privilege. Some of our clients undertake to do these analyses internally, typically in a somewhat less sophisticated way, but some clients are fully capable of doing even the sort of sophisticated analysis that you see on the screen here. The problem is you never want to see this sort of analysis exposed in litigation. It is the ultimate airing of dirty laundry, including these numbers that will allow us to make adjustments to eliminate any present disparity against any particular protected group. And so within the context of an attorney-client conversation, what you may do if you see a statistical disparity like this is look at the number of people who appear to be in excess of what you would expect would be impacted by the given transaction on the table. And you go back to the management team, maybe through the human resources group, and you sort of pressure test the selection decisions, review them, make sure that you're comfortable with them. One thing that we counsel employers never to do, and you'll see this amply footnoted on the form, is you don't make decisions based on these statistical analyses alone. That is likely to create more problems than it solves, because anybody who becomes impacted by the RIF as a result of that rejuggling of people has a natural argument that they were ultimately included in the RIF because of their own demographic considerations. In other words, if you were trying to resolve the disparity against women, and the way that you undertook to resolve that disparity was to not lay off a few more women and to lay off a few more men, those men may have a claim against you. So it's a very subtle exercise that really should be undertaken with the benefit of counsel. The other thing I will say about it is, and we can move on to the next slide, something like this is only really useful if you give yourself time to react to the results. It's not uncommon for clients to come to us on the eve of a layoff and present us this information and ask us to do a disparate impact analysis. And what I tend to tell folks when that happens is the results aren't going to be very useful to you. You're just creating a document that may not be flattering in terms of the transaction you're about to undertake. And unless you're in a position to go back and pressure test the selection decisions that you've made, that document's just not going to help you very much. So our net advice on that is get the list, tentative as it may be, in a form that's good enough for us to analyze and get that to counsel well in advance of the layoff so that you can react to whatever it is you may find. A few other things that you'll see on the slide here really just revisit a couple of points I've made along the way about how we use these disparate impact analyses. So I don't think I need to belabor that. Moving on to yet another way that we can reduce risk in the layoff context, and Brooke, you can take us to the next slide, release agreements. There's nothing new or groundbreaking about the notion of using a separation agreement in the context of a reduction in force. It's pretty common practice. And it's probably the single most effective thing that you can do to reduce liability coming out of a mass termination event. It, of course, depends on the employees signing the agreements that you put in front of them. And that is typically going to be a function of how much severance you offer in exchange for the release agreement. That is the fundamental exchange that's posed by a separation agreement. We are giving the employee some amount of money in severance, which could be cash, could be benefits continuation, could be something else of value. And they're giving us a release of any claims that they might assert based on their termination or any other event that's happened during their employment. So if you got 100% of the affected employees to sign a release agreement, your litigation exposure plummets to not zero, but close to zero. Historically, when I began doing work like this most of 20 years ago, a standard severance agreement would be a pretty beefy document. And it included a lot of things that an employer would like to have in its ultimate resolution with an employee. But a lot of those provisions have really come under attack in the last couple of years. And for example, confidentiality clauses that call on an employee to maintain the secrecy of, say, the severance that they were offered, have become very disfavored by the plaintiff's bar, and that same sentiment has trickled up into a number of federal agencies. So we now have the National Labor Relations Board, for example, taking the position that certain provisions that we would have typically included in a separation agreement a couple of decades ago may actually be unfair labor practices. And the things you want to think about are confidentiality provisions, non-competes and other restrictive covenants, which might be regulated by any number of statutes, and non-disparagement provisions. Those are really the three things that have drawn a lot of fire from federal agencies. And initially, there was a great deal of resistance from the management bar and organizations chafing at what the federal agencies were doing and fighting about including restrictive covenants and all these other things in release agreements. Our advice, having watched all that play out, is typically to think real hard about what you really need in these release agreements. One thing you really need is a release, but do you need confidentiality? Does it really matter? You know that the employees are likely to talk about the severance that they get. You know that the severance that they get is probably driven by a formula in most cases. And so the juice may simply not be worth the squeeze. And our practice has become to narrow these agreements down rather than make them as comprehensive as possible, but to really focus on what you need and limit the agreement to exactly that. One other consideration that's important in the context of release agreements is the Older Workers Benefit Protection Act, the OWBPA, which is an amendment to the Age Discrimination in Employment Act, the ADEA, both of which are federal statutes that prohibit age discrimination. As most of you probably know, under the ADEA, any employee over 40 has 21 days to consider an agreement that's presented to them in the context of a termination, and 7 days to revoke it after they've signed it. If the employee doesn't get those two benefits, then the release of age discrimination claims in the contract is just void as a matter of federal law, and the employee could take the severance pay and sue you for age discrimination nonetheless. In the layoff context, those yardsticks move a little bit, and for purposes of the Older Workers Benefit Protection Act, something that triggers these layoff-related requirements is any severance program affecting 2 or more people. So if you're undertaking a reduction in force that is intended to reduce operating costs or deal with elimination of a line of business, all of the factors that Alex talked about, and you're offering severance to 2 or more people, i.e. more than one person, then they're going to get 45 days instead of 21 days to consider the agreement that you provide them. There are a few other requirements that have to be included in any ADEA compliant release. It has to be in plain English, has to specifically refer to the statute, has to not release future claims, and it has to advise the signing party to consult with an attorney about the decision to enter into the reduction in force. None of that is layoff specific. The last element you see on the screen is layoff specific. And anytime you're doing an OWBPA covered reduction in force, in addition to the severance agreement that you provide folks, you have to provide them this OWBPA disclosure. And that is on the next slide. There's regulations that define what has to be included in this disclosure, but there's no magic to this form. There's a few different ways that it can be laid out, and there are 2 essential elements. The first is you have to designate people by job title and reflect who was selected for layoff and who was not by age. And that's the information that you see laid out on your screen here. And typically, you're going to do one of these OWBPA disclosures for each decisional unit that we've talked about already. So you may have several of these in the context of any given RIF if you've segmented your workforce and analyzed it that way. The other thing that this has to include is a statement of the basic criteria that the organization was applying in deciding who to include in the reduction in force. And there again, there's a legal argument that if you don't do those 2 things, your age discrimination release is not valid and the employees can still sue you for that. So you want to make sure you get that right. That'll take us to the last substantive slide, which is on the WARN Act. WARN is a federal statute from 1988. It's the Worker Adjustment and Retraining Notification Act. And in essence, what WARN does is require an organization to provide 60 days advance notice to folks who are impacted by a WARN qualifying event. And we've got a whole nother micro webinar on WARN. It is a set of detailed and arbitrary requirements that may apply. The baseline, though, is it applies only to sites of employment where an organization employs at least 100 individuals. And then there are a couple of triggers that are implied or stated. First is a plant closing. So anytime you close a plant that had at least 100 people in it and more than 50 of them lose their job, you have a WARN event. In the reduction in force context, a WARN qualifying event is a reduction in force of at least 500 employees or at least 50 employees that constitute 1/3 of the employer's total workforce at a given location. One very important word of caution here is that what I've described to you as the Federal WARN Act, there are many states that maintain what we call mini WARN Acts that have lower thresholds for the notice requirements that I've described and may have various other entitlements that employees have in the context of a reduction in force. So you need to check state law and make sure that you're not tripping a state mini WARN threshold in addition to looking at the Federal WARN Act. And one thing that I said in the setup here is that these are notice statutes. They don't necessarily require you to provide severance pay to employees. They just require you to provide advance notice to the folks whose positions will be eliminated. One huge and important caveat to that is New Jersey. We see continued state action in this space, and New Jersey just radically revamped its mini WARN Act law, and it is the first in the country to actually require severance pay in that context. And it's 1 week per year of service. We'll deal with those issues in our subsequent series. Before I give you the preview of coming events, I'll read off the CLE code, which is SS 7471. That's SS as in Seyfarth Shaw 7471. And then the next slide is that preview of coming events. We're going to talk more about separation agreements and the approach that I described to them. We're going to really dig into WARN Act issues, which Alex is looking forward to. And we're going to talk ultimately about a very timely subject, which is the use of advanced technology in making RIF decisions. So that's our program for today. Thank you all for joining us. We hope it was helpful to you, and we look forward to seeing you or you seeing us at the next several episodes.